whenever there is an FER, the FER by definition will raise some objection or the other. It's a part of the process. So whenever the FER raises an objection, you can broadly get over an objection raised in an FER in 3 broad ways. The 3 broad ways may not be applicable in all the cases, but I'm just telling you as a principle, there are 3 ways in which you can get over an objection raised in an FER. The first one is by argument. Argument to say that this is something different. The scope of my claim is different. When you interpret the claim, the prior art does not cover my invention. My invention, when it's interpreted, it falls outside the scope of the invention. When there is a claim to claim mapping, or when there is a prior claiming, there's a concept called prior claiming. When an objection is raised that your claim is actually claimed prior in another application, then what you would do is you would try to ascertain the scope of the claim, of the prior claim, and say that the scope of that is different. That is provided the language and the technology allows you to do that. So the first approach of a patent agent or of a lawyer appearing before the controller is to argue their way out, or to argue and say that that is different, not applicable. The teaching of that prior art does not apply to my case. So the first way is legally argue to get your way out. Now, if that is not possible, there is a way in which in some cases you can get over by a reference. Now you will see that potential infringement, there's a provision on potential infringement. If an objection is raised, then you can get over by a reference. You can just say that, okay, I will make that particular reference, please grant me the patent. Saying that if I can enter into my complete specification that there is a reference to a prior art, with that, please grant me the patent. So that's the second way. The first is you try to argue yourself out. Second is by reference. Third is by amendment. To satisfy the objection, you amend it to get over the objection. So these are the broad 3 ways in which you get over any objection in an FER. So if they tell you these are the objections in FER, how do you get over it? Is first you will have to say that given the facts of the case, if it is possible, I will argue to say that this is different. This is only a synthetic extract of a naturally occurring substance. It is not the naturally occurring substance itself, for instance, to get over the anticipation by traditional knowledge or use of plant parts. So this will be the argument part. Second, reference is limited to only few cases, like potential infringement, you say the reference. And amendment is the approach of choice, because when you amend, the patent office is also happy because patent office pointed something, you changed it. So amendment is the norm. In fact, normally patent agents will argue and then also by way of abandon caution also have an amendment along with it. So if the argument doesn't work, at least the amendment would do the job.